Right. I would like to introduce our next speaker, whose name is Mr. Bill Turner. Bill is in charge of the Federal Office of Drug Control and has the responsibility of writing the regulations around the cultivation and manufacture of medicinal cannabis in Australia. Today he's going to give us an update from the Commonwealth. Bill is trained as a veterinarian and has had a 21-year career in the public service, working in a wide range of roles that include veterinary officer in charge on export abattoirs, trade negotiations, diplomatic representation, and grant program administration. From May 2011 until February 2016, he has worked in the Therapeutic Goods Administration, firstly as the head of the Manufacturing Quality Branch, and then the Scientific Evaluation Branch. With the formation of the Office of Drug Control, Bill is now responsible for the regulation of the illicit manufacture of narcotic drugs, their import and export, and reporting to the International Narcotics Control Board. The Office of Drug Control is in the process of putting together the enabling regulations that will implement the framework for the cultivation of cannabis for medicinal purposes. Ladies and gentlemen, please put your hands together for Mr. Bill Turner.
Good afternoon. I hope you're all well fed and ready to listen to some really interesting stuff. I'm not going to excite you with a lot of science, as the speakers did this morning. In fact, I'm just going to bore you with regulation. So, first thing I need to talk about is going to be kind of disappointing. I can't be very heavy on some detail today. If you're following the news, you might have noticed that the Prime Minister made a trip to see the Governor-General last weekend, and the Governor-General has duly dissolved both Houses of Parliament, and we are in what is called caretaker mode. And during caretaker mode, public officials like myself are not allowed to talk about policy that might bind any incoming government, which means I can talk about the facts pretty much only. So in talking about that, there's two groups of things. There's things that are facts and there are things that are under development. The legislation that will enable the cultivation of cannabis for medicinal purposes was passed in February with bipartisan support and in record time. Matthew mentioned earlier that he managed to get his legislation in on the 8th of December and it managed to get passed on the 12th of April, if I quote you right, Matthew. Our legislation got debated in the House of Representatives on the 23rd of February and it passed the Senate on the 24th of February, which actually started my heart beating because as soon as it passed, we're getting close then to having to implement and the clock started ticking. And in fact, I rang what is called a legislation liaison officer within the department and said, when does royal assent happen? And she said, oh, don't worry about that. It's a month, maybe 2 weeks if the Attorney General's around. It was 3 business days, so we got royal assent on the 29th of February, which has meant the clock has started ticking on things. That's actually a typo I put in there, and I don't know why I did it. The latest commencement date is actually the 30th of October. It's 8 months and 1 day after the royal assent. And that's written right there in the legislation, so I'm allowed to talk about that because that's a fact. Regulations. The regulations will cover the detail of the legislation. They're currently under development and will continue to be under development for a little while yet. And they will contain what we could talk about as policy that is not in place until those regulations have been approved by the government. And at this point in time, as I mentioned, we don't actually have one. We're in caretaker mode. So as I go through this presentation, where I'm talking about regulations and stuff that will need to be sorted out in that detail, I will be a little bit cryptic about it and won't give you as much detail, and I'll mention that specifically. For the rest of the time, I'm talking about legislation, stuff that's matter of public record. So I'll go through briefly and I'll explain who the Office of Drug Control is. And then I'll talk about the chain that we're putting in place for for medicinal cannabis, and I'll start at the end of the chain, the patient access. Then I'll talk about manufacturing requirements, and then I'll talk about cultivation and how you go about acquiring a license. And I'll talk about having to have a business relationship with a licensed manufacturer, the fit and proper persons test that applies, a requirement about employing suitable persons, and then some growing security requirements. So, who are we? The Office of Drug Control administers the Narcotic Drugs Act 1967, which has for nearly 50 years managed our manufacture of licit narcotics, principally the opioids that are extracted from the poppies that were until recently grown in Tasmania. That's a really important point because we do that work. We are enacting Australia's obligations under what is called the Single Convention on Narcotic Drugs, which is an international treaty that was signed in 1961, which covers how countries manage illicit narcotics. And whether you agree with it or not, cannabis is in that narcotic drugs, the Single Convention on Narcotic Drugs, and globally is considered to be a narcotic drug. And as such, Australia is bound by those obligations. And much of what I'll be talking about is how Australia is going about implementing those obligations. We also administer the Customs Prohibited Imports Regulations, 1956, not all of them, just Regulations 5, another typo, 5G and 5H. And we administer the Customs Prohibited Exports Regulations, which aren't particularly relevant to this particular discussion. We sit in the Department of Health, and I'll stress that we are not the Therapeutic Goods Administration. The Drug Control Section, which is the substantive part of the office at the moment, because I'm still trying to staff up the medicinal cannabis section, that has had a home in the Therapeutic Goods Administration. It's also had a home in the Office of Chemical Safety, which you see next to the Therapeutic Goods Administration, and in various other parts of the Department of Health. But since the formation of what's called the Regulatory Services Group early last year, Therapeutic Goods Administration, what is known as the Therapeutic Goods Administration, is effectively the elements of the Department of Health that administer the Therapeutic Goods Act. We administer different legislation, and as such we're a separate entity to them. The other group within the Regulatory Services Group is the Office of Gene Technology Regulator, which may or may not have a role in the regulation of cannabis, depending on whether GMO cannabis was brought in. I have no position on that. I heard the very strong view put earlier, but it is a possibility. Right. Now, I always start when I'm talking about this at patient access, and the reason I do that is because it is kind of central to what we're trying to do here. And I quite often will try and address a misunderstanding, I guess, about medicinal cannabis and its place in the Australian healthcare system. In theory, at least, subject to some nuances in state and territory law, medicinal cannabis products can have always been able to be prescribed in Australia. Why haven't they? I think there's a lack of awareness about that, but also there's a lack of supply globally of suitable products that could be prescribed. So the amendments to the legislation to the Narcotics Drugs Act that Minister Lee put in place, introduced into Parliament in February, was specifically about addressing the supply end of the chain. I start at the patient access end because it's all tied together. The intent here is to put the medical profession central to decisions on using medicinal cannabis, and I think to date they've been a bit missing in that area. There's a lot of work that needs to be done on in that space. There is education, and I think you'll be hearing a bit about that a little bit later in the program. And there is a lot of work still to be done between the TGA and the states and territories on working on a nationally consistent approach, as much as we can do in a federated system, towards ensuring a consistent approach to how patients will get access to this. With respect to the Therapeutic Goods Administration, the legislation provides four channels. I've only listed three because they're relevant to the immediate situation, but it provides four avenues for access to any product. The first one's clinical trials, and any product under a clinical trial can be legally prescribed through and supplied consistent with the Therapeutic Goods Act. There is a thing called the Special Access Scheme Category B, where doctors, where in their professional judgment, they think that a patient may be able to benefit from a unregistered therapeutic good, can apply to the Therapeutic Goods Administration to have an approval done for that good. And then there's authorised prescriber. An authorised prescriber is similar, except that the doctor is authorised to prescribe a certain product to a certain patient group. Now, all three of those routes have always been available for supply of medicinal cannabis to patients. The clinical trials route is the one that is being utilised by New South Wales, and I'm very happy that they are doing that, because I think the body of evidence for all this needs to be built and established. An authorised prescriber has never been used, but I can tell you that Special Access Scheme has been used sparingly from time to time. Where it interacts with states and territory legislation, the drugs and poison legislation, that's where I talked about nuances. So, for example, until December of last year in Queensland, it just wasn't possible. They had to make some legislation changes. And in fact, in the ACT at the moment, it still isn't possible. So, for example, even a registered product like Sativex can't be prescribed in the ACT. The other interaction, of course, is cannabis-specific legislation. Matthew talked to you about what Victoria has done. Queensland has introduced their own legislation recently, and Tasmania has made announcements about a scheme as well. The Therapeutic Goods Administration is working with all of the states and territories to ensure that there is a consistent approach to patient access. Once that's established, we can move back into the chain, and we're now manufacturing products that can be prescribed under those systems. A manufacturer will need up to 3 licences. They'll need one from the state and territory. They'll need one from the Office of Drug Control under the Narcotic Drugs Act, and they'll need one from the Therapeutic Goods Act, under the Therapeutic Goods Act. The Narcotic Drugs Act licence deals with a number of issues. Firstly, security. So one of the overarching principles of the single convention is that governments, in making access to narcotics possible, they prevent diversion. So there are security requirements that will have to be applied at the manufacturing end. Secondly, it allows us to control the amounts that are manufactured. And again, under the single convention, Australia is obligated not to allow stockpiling of any narcotics. So we do this by issuing permits which stipulate a level that manufacturers are allowed to manufacture to. And those permits also then aggregate into reporting that we have to do to the International Narcotic Control Board, which is a UN agency based in Vienna. We have to report quarterly on consumption and use of narcotics, and we have to provide to them estimates of what our future use is likely to be. Those estimates are very important because they absolutely regulate export and import of products and the trade globally. If we put in an estimate that is too low on any particular narcotic, and it has happened to us occasionally, trade freezes immediately, because the systems that we use look at our approved estimate. It says that we have used it up, so therefore you can no longer import. So that's what the Narcotic Drugs Act licence does. The Therapeutic Goods Act licence deals with a critical issue in the medicinal cannabis space, and that's around the quality of the product. So patients that are currently or have been accessing medicinal cannabis off a black market are unfortunately exposing themselves to some unknown dangers around the quality. We don't know whether there's contamination with bacteria or fungus or other toxins that may affect their health. And in fact, we don't know what's in the product whatsoever. There may be no cannabis, for example, no active ingredient. Through the application of a Therapeutic Goods Act licence and the application of what's called good manufacturing practice, quality of product will be determined or ensured. To get a licence under the Narcotic Drugs Act, a manufacturer will have to be able to demonstrate to us that they will be able to supply through clinical trials, the Special Access Scheme Category B, or authorised prescriber. Now that's a critical point here. We're not going to be handing out manufacturing licences on speculation. People need to be able to demonstrate that they're supplying a demand that exists. Again, that's to ensure that we don't overproduce, but it is also to ensure that the security of the supply chain is kept as tight as possible. Which brings me to cultivation, and the reason I've worked my way backwards from patient access. As you can see, patient access determines the demand. The demand determines how many licenses or where the licenses go. And then a cultivator, to get a license to cultivate medicinal cannabis, will need to be able to demonstrate a business relationship with a licensed manufacturer at the first step. So they will have to come to us and confirm to us that they are supplying to somebody who is already licensed to manufacture. And then, once they've got the license, they will need to come to us for a permit as well. The permit will stipulate the strains they're allowed to grow, how many plants they're allowed to grow, where they're allowed to grow it, over what period of time. In getting that permit, the cultivator will have to be able to demonstrate to us that they have a contract with that licensed manufacturer. So the chain will be kept very, very tight and narrow. One of the things we're trying to prevent here, because it creates an enormous inefficiency in the system, and if I can use my colleagues in Canada as an example, they didn't set those sorts of boundaries on their licenses. As a result, since they started up their licensed producer system about 3 years ago, they've managed to license 27 or 28 licensed producers. They've had over 1,400 applications, 400 or so of which have been rejected, but they've got 1,000 sitting in queue. So we're trying to prevent that big queue. We're trying to make sure that the business runs to meet the demand of the Australian patient. One of the things that has been talked about a lot out in the media is the potential for exports, and we're not ruling those out, but the legislation at this point in time does not allow for export of either the raw material or the finished product. That's done for a number of reasons. Primarily, we're focused on Australian patients, and we want to make sure that Australian patients are the ones that benefit from what we're doing. But secondly, and more importantly, if we are going to export, we need to have the confidence of the international community in what we are doing. This is going to be a new system. It's going to have some trial and error and some rough spots and some things that we didn't quite think about. The more avenues that we have where the cannabis is moving, the more chance we have for unintended diversion and for failure of the system. If we get that, we won't have the confidence of the international community, and so exports may not be able to grow. Our trade with the international community very much relies upon our ongoing reputation. And Australia, as an aside, or an important aside, Australia provides 52% of the illicit opioid narcotics in the world, and that is built on our reputation for a safe and robust system which has been developed over 40 years. Failure in either of those spaces can affect our ability to continue to service that market. The contract will have to cover a number of other things that will be set out in regulations. Those sorts of things that we're considering and thinking about will be who's responsible for the transport of it, how the quality of the raw material will be managed. But as I said before, those are matters that will eventually be set out in regulation, and we're having discussions about them now. Moving on, to become a cultivator, you'll have to be a fit and proper person. That's a legal term. It's written into our legislation. You will have to, the fit and proper persons test covers such things as whether you've been convicted or have any civil penalties against Commonwealth, state and territory law, what your connections are with other persons. So, to put it bluntly, do you have organised crime connections? That's not going to allow you to be a fit and proper person. Do you have appropriate business background, and do you have the financial ability to meet your obligations? Do you have the capacity to comply with the licence conditions, whatever they may be? And some of them are set out in legislation. There's some very specific ones, and I'll talk about them a little bit later on. And some of them are still being developed. Are you a person of good repute? These are matters that will be taken into account in trying to determine whether a licensee or an applicant for a licence is a fit and proper person. And under the legislation, the decision maker must refuse a licence if they're not satisfied that an applicant or their relevant business associates are fit and proper. So it doesn't just apply to the applicant, but it applies to the people that may have influence over the business. The decision maker must also be satisfied that the applicant hasn't committed a serious offence in the last 10 years. Serious offence is defined, and it deals with fraud, drug offences, those sorts of things. And this is different to the test in the fit and proper persons test, which says whether you've been convicted or not. This is whether you have committed a serious offence in the last 10 years, whether or not you've been convicted. The decision maker must be satisfied that the applicant will ensure the security of the product. And that means that there can be no diversion outside the supply chain that is being established. The security principles themselves are not set out in the legislation. I will talk about them a little bit in a little while in broad terms, but they're matters that will be determined through guidelines and the regulations, and as such fit into that area of policy in which I can't give too much detail. The decision maker has to be satisfied as to the location of the potential enterprise. We don't want this setting up near sensitive and vulnerable areas such as schools and those sorts of things, and we don't want it to breach local planning laws. So it's a matter that will be taken into account. An application fee, and I should have written there if any, because it's not established in legislation yet that there will be an application fee. But if there is an application fee, that has to have been paid. And an applicant must have responded to any requests for information that we need. So when you all apply, a licensee will, or an applicant will give us a bunch of information, and we may need clarification on that information. We'll ask for additional documents to cover that. If they haven't got a reply, we're unable to grant the licence. Right. You've passed all those hurdles, and now you're a licensed cultivator. It is a condition on the licence set out in legislation that you employ suitable persons. So the fit and proper persons test, which is about making sure that you are a suitable person to run a narcotics cultivation business, that you don't have inappropriate ties with inappropriate people, that you have the money to be able to carry through, that you have the business acumen to be able to do it. One of those things will come, so we're controlling the licensee with respect to the potential for diversion, but the other risk factor is where employees might be able to put it crudely, pocket some of the product and take that home with them. That can't happen either. A suitable person set out in legislation must be over 18 years of age and must not have had a conviction for a serious offence in the last 5 years, and such other matters that are prescribed in regulations regarding criminal record, their employment history, and matters that are being considered in this space are whether they've got a drug addiction, whether they've got a history of drug addiction, and so on. Right, growing and security requirements. Now, as I said, central to the government's policy is ensuring access to consistent, high quality product. We have an obligation under the Single Convention on Narcotic Drugs to prevent diversion of any cannabis grown for medicinal or related scientific purposes. And in doing that, we intend to be as consistent as possible with international practice. Most of the detail, as I said, will be set out in regulations. So I'm going to talk about the Canadian security requirements because those are facts, and I can talk about facts. The Canadian security principles are around preventing and monitoring unauthorised access to a property where cannabis is grown. So this means no persons can get onto the property unless they're authorised to do so, and you're able to track that a person who to monitor whether somebody has tried to breach your perimeter security. There needs to be controlled access to the property, which will mean only the persons that are allowed to get on. If they're employees, they're registered in every day. If they're visitors, they come in and they are appropriately signed in, and their access to the cannabis is appropriately secured. Access to cannabis is restricted to only as necessary to undertake duties. So, for example, there may be people who are employed to deal with the propagation of the crop, and in a Canadian system there's what's called a mother room, and in that mother room is the plants from which cuttings are taken, and in the event that it's necessary, plants may even be allowed to go to seed. If you're employed to be the accountant, there's no way you should ever be able to get into that room, because there is no good reason for you to do that with respect to your duties. If you're employed in the main cultivation room but have no business being in the mother room, the access needs to be restricted. All access to cannabis in the Canadian system is closely monitored under CCTV, and recordings are kept to assist investigation of incidents. So if something goes missing, they can go back through the tapes and see what happened. The end result of all of that, and I know that Canada has a very cold climate, and that's a very telling factor in all of this, but coupled with those principles, it's inevitable that the cannabis in Canada has to be grown indoors. Other conditions that are on a licence. There is an obligation to inform employees of their obligations. So very important that employees understand their responsibilities and why it's important that they don't deviate from those. Activities are only undertaken under permit. So a licence is not sufficient to get you plants in the ground. You then need to have a permit as well. And as I said, that sets out the amounts you're allowed to grow, the strains that you're permitted to grow, and other matters. I think it's actually a good two-stage process indeed, because one of the ways that we will be administering this, or the way we intend to administer this, is that you can get a license without actually having constructed your facilities in the first instance. Right? You can tell us what the security arrangements are going to be. You're going to tell us where the buildings are going to be. You can tell us where the activities will take place, plus all the other information that we need to assess fit and proper. And if we're satisfied on that, we give you a license, and then you go away and construct the facility. When you get to permit, we'll need to make sure that those facilities are in place and that the security provisions that that we've authorised are in place, and that will take place under an inspection. A licensee must allow authorised inspectors onto the property, and when I say must allow authorised inspectors on the property, there is a bit of a there's some boundaries around that. That's during business hours. If we want to come in outside business hours, we have to go and get a warrant or your permission. But during business hours, it's a condition that authorised prescribers be given, authorised inspectors be given access to the property. I've mentioned that a licensee must hold contracts. The Office of Drug Control must be notified of certain things. Those things include any matter that may affect your ongoing ability to manage the cultivation industry, including matters that may affect whether or not you're fit and proper, or your business associates remain fit and proper. So, in summary, the system is driven by patient demand, and that's critical. We're trying to put the medical practitioner back in the middle of all the medical decisions about the use of cannabis in patients. The manufacturers can only supply through certain routes under the Therapeutic Goods Act and in tandem with state and territory legislation, and the Therapeutic Goods Administration and the state and territory health departments are currently working through ways and means of making sure that happens as seamlessly as possible. Cultivators must have contracts with manufacturers. This controls the supply end so that we meet our international obligation to ensure that we don't overproduce cannabis and have stockpiles sitting around. I must say on that, the Commonwealth, the Office of Drug Control, has the power to order the destruction of any and all crops at any time should it be necessary. That is necessary to ensure that we don't stockpile, but it is also will be a necessary action if we need to take regulatory action, such as suspending or removing somebody's licence. The licences are subject to strict conditions. Many of those are set out in the legislation, so I've mentioned those. There are still more, and in fact, the legislation says that the decision maker is not limited by the legislation, and so conditions can be tailored to a particular circumstance. And finally, and most importantly, there will be strict security requirements in place. I'd have hoped to have given more detail on those, exactly what they're like, but as I said, we will be looking at international best practice. I've given you the example of what happens in Canada, and I can't imagine it'll deviate too much from that. So with that, and I've noticed nobody else has invited questions, but I will. For import licences, look, when we get applications for them, we will process them, and we do so. I know what you're trying to push here. That's a matter that's under another process at the moment, and I'll refrain from talking about that. So we'll make a distinction. So the question was, there's good agronomic reasons to grow this outside in the open air, sunlight and all the rest. Look, I think we'll make a differentiation. So when I talk about indoors, I'm talking about inside a secure area which can't be accessed and can be controlled. There is no reason why glasshouses couldn't be secured in that fashion. But I'll put the caveat, no decisions are made on this as yet.
What about a
I can't enter into too much debate over that, again, because it's a policy issue. I wouldn't read too much into what I say because it's a policy issue which hasn't been determined yet.
So maybe 3 more questions.
Yep, 3 more questions I'm being told, and the host has one, so I have to defer to her.
When the legislation was passed in February, the federal government agreed to the adoption of an expert advisory council. I'm just wondering about that process. Has that started? Has anybody been appointed to that advisory council?
So the advisory council hasn't been appointed. Work was done on it, but the election is called, and we can't appoint ministerial councils during an election period.
Advisory council. Does that mean then that the regulations are being written without any input from experts?
So the regulations are being drafted, yes, but that would always have happened. We do have some tight timeframes on this. It will depend upon any incoming minister, and I say that in recognition that whoever is health minister will be a reflection of the will of the people as they vote on the 2nd of July. And so that discussion will happen with any new minister, and we'll work it out from there. Sorry, I should have mentioned that, yes. Look, I've talked primarily about the supply chain for patients, because I think that's what most people are interested in. I think the very strength of the Australian system is that it keeps research right there in the middle of it, so clinical trials can be enabled and are going ahead. There are 2 types of licences under our legislation, one for cultivating for patients and one for research specifically. So yes, there will be research licences. They'll have slightly different conditions and slightly different chains and requirements for us to determine that. So how you go about applying for licences, that will become apparent as the framework develops. There will be a website which I hope to get up very soon, which will have more information on it as we're allowed to release it. But in answer to your question, there's nothing to stop a vertically integrated enterprise that has manufacturing and cultivation as part of the... they'll have 2 licences, of course, but there's nothing to stop that. And I'm sorry, there's hands up, but I got told 3. One more here. So in that space, as far as strains go, that will be determined at the patient access end. So that will be the area where products will need to be defined, and then the strains that are needed to make those products, the manufacturer will contract to the cultivator to make. From our perspective, we're not saying before we start these are the only strains you can grow. It's what the demand specifies for us. Once there are strains in place, let's say, for example, it's a low THC, high CBD strain, there will be capacity for us to sample crops to ensure that is what's being grown. No firm decisions made on that I can talk about. It's a matter of policy. What I've said is that if you look at the security principles that applied in other countries, and I use Canada as an example, then one outcome is that it could be grown indoors.
You say that Australia has a really robust way of ensuring that opiates, the poppies, are cultivated. In fact, we've been perfecting it for 40 years. So why don't we simply apply what we're doing with the poppies to cannabis, and it's all ready to rock and roll?
Now that's a really great. That is a really good question, and the answer to it is that the requirements for what we do for poppies in Australia is different to the requirements needed for cannabis under the single convention. So we have to have respect for what the single convention sets out. Now, if you want to drag out the single convention at some stage and cure your insomnia, please do. But in reality, if you read the bits that we are trying to enact here, which is Article 23, it actually talks about poppies and opium. We don't do Article 23 for poppies in Australia because we don't do opium. And it's a very important distinction. Article 28 says that if you grow cannabis for medicinal purposes, you have to do Article 23, substituting poppies for cannabis. The difference between the two crops is that cannabis is immediately divertible from the plant, whereas the poppies, unless you're producing opium, and I won't tell you how that's done, unless you're producing opium, it's not an immediately divertible crop from the field. It can't be used and abused immediately from the field. Both systems have to work together, and those are the issues that the TGA and states and territories are working out now on how that might work. Yep. My 3 questions. One more.
The answer you gave regarding poppy growing, I'm from Tasmania.
Yep.
We've grown poppies for a long time there.
Yep.
I'll disagree with your comment that they're not divertible straight from the paddock. All we have in Tasmania, in terms of security around the crop, is a barbed wire fence, possibly electrified, and a sign that says poison, keep out.
I agree. I understand, yes.
Recently, we've had Danish tourists, 2 of them die from picking thebane heads, which are the thebane as opposed to the normal morphine poppy, out of the paddock, cooking up and dying. So to say it can't be the virgin killing you out of a paddock is nonsense. And so we've got a conundrum here where we're saying here's a crop that won't kill anybody if they have heaps of it.
So
there's still contradiction that needs to be addressed.
And I'm very aware of the sad cases of deaths in Tasmania, but they are isolated, and the distinction here again, and those cases highlighted, is that it's not readily abusable. It's not something where you can go in and get high off it. You run a risk of death, yes, which is unfortunate, but I'll go back to what I said about the way the single convention works, and that's the primary international agreement that deals with this. And I'd say we don't want to be making an argument that the poppies need to go under more security, because that's kind of where you're leading to. Because if we had to do Article 23 to poppies, which we don't have to, then the conditions would be very different. Pardon? Well, changing the treaty is not as easy as you'd like to. Yeah, I often ask that question. It's not going to happen immediately.
Thank you very much, Bill.